All right. While we're waiting to see if we have someone to do the mask ceremony, I'll do quick introductions and tell you how this is going to go for the next 56 minutes. My name is Craig Goebel. I'm the Chief Executive Officer of Legal Aid Saskatchewan. And I won't have much to say this afternoon. I'm sort of the wrangler of the three main panelists. To my left and first on your right is Mr. Jim Scott, a long-time, long-serving, experienced defense counsel, criminal defense counsel in Saskatoon. And Jim has had the most recent experience with the Marlene Carter dangerous offender application and a Gladue report, in which that Gladue report was of some value. Next to him is Professor Jane Dickson from Carleton University. She's an associate professor of law and legal studies, and she will be providing us with some of her impressions and thoughts about what's going on in Ontario, and has also, Jane has done a fairly significant number of Gladue reports, mostly for Ontario, so she has a fairly in-depth knowledge of what's good, what's bad, and will help us with some of those notions. And taking his ease at the far end of the table is Judge Cunliffe Barnett. And Judge Barnett is a retired judge of the Provincial Court of British Columbia, adjunct judge of the Yukon and Northwest Territories. Judge Barnett has helped in Saskatchewan to introduce and train Gladue writers here. So with that, I will then, since we don't have a mask ceremony yet, I'll just say this, that when I started as the Chief Executive Officer at Legal Aid about 3 years ago, I met with the lawyers around the province, as would be the case, and there was a lot of expression of what seemed to me to be a pent-up demand among the lawyers on behalf of clients for Gladue reports, or some impetus on behalf of Legal Aid and its clients to do Gladue reports, with an indication that the judiciary might welcome them, or we don't know what would happen, but let's try something. So I had previously worked with Legal Aid in British Columbia, where Judge Barnett was instrumental in training people in British Columbia to do Gladue reports. And I would refer to the ones that I'm thinking of as comprehensive written reports, not a portion of a PSR or something like that, but something that is substantively investigated, written, and produced. So with that, we sort of embarked on a program of introducing, or figuring out a way to introduce, a pilot project. We got some funding from the Law Foundation to raise consciousness and raise knowledge among defense counsel and actually among some probation officers. And we started off with that kind of a proposition, that we would have to import people who had previously done, again, comprehensive written reports to help train local people who were interested in providing that service to clients. And we put together a pilot project, which is ongoing, which we will evaluate over the course of the remainder of this year to determine what else we can do. Quite a number of reports are on the go right now. I think about a dozen are in the hopper, as it were, and about 4 to 6 have been introduced and submitted to the courts with varying degree of utility, but at least all of which, to my understanding, have resulted in there being some positive comment from the judiciary. So it's going to be a long process, there's no question about that. And we're not tied or wedded to any particular way of doing things. We want to do the best that we can do for our clients. And I'll close my comments to introduce this segment by saying that as a defense counsel, I think it's incumbent upon defense counsel to be in the forefront of this kind of initiative and not rely on government or Native organizations or others of good will to do this. And so we want to be clear that if there's a stick and there's a point at the end of the stick, it's defense counsel who should be on there. So with that, I'll turn over for the next set of comments to Jim.
Thank you, Craig, and for that introduction, and also thank you for all the work that you've done to help promote Gladue and the rights of Aboriginals here in Saskatchewan. I think it's you're one of the unsung forces here in Saskatchewan, and I think you deserve more credit that you're getting. As a criminal defense lawyer, and nearly all of the women that I have defended and represented are Aboriginal, I've never seen punishment and imprisonment as a remedy for the cycle of abuse and self-harm. Abuse by the state, abuse by the Crown is no different from abuse by an individual. All abuse is the same in my books. It's abuse fosters abuse, and respect and kindness and consideration foster respect and kindness and consideration. And all the Aboriginal clients that I've defended are worthy of respect. All have a strong and resilient ability to deal with adversity. They, unfortunately, every one of us has a breaking point, and all of my clients share a common history of colonization and residential schools. Now, Professor Maria Yellowhouse Braveheart conceptualized the notion of historic trauma, especially if we're dealing with First Peoples in North America. And Professor Braveheart's work on historic trauma has fostered a rich and growing field of study. But the harm done to my clients is also an ongoing trauma that's in the present. So the social welfare system continues to separate children from their mothers, from their parents, their caregivers, and place them into other homes, and that's a source of trauma. And the criminal justice system continues to break up families and friendships and punish and humiliate people, and that causes trauma. And the ongoing colonization, particularly under the Indian Act, causes trauma. And the general animosity and racism that is directed against Aboriginals by the larger community also is a source of trauma. And the humiliation of Aboriginals by not having their, and ignoring those who were lost through the process of settling and colonization, that causes a sense of shame and I think a sense of injustice. The community is showing disrespect to the descendants of the victims of Saskatchewan's ethnocide when the community does not consider the victims of Saskatchewan's settlement as worthy of memorial. And also mining and industrialization of Aboriginal communities can cause an eroding of culture. The resiliency of Aboriginal people in the face of all these insults is extraordinary. And there are strong Aboriginal leaders and academics who are speaking out and taking control and making a difference. And it would be wrong to label Aboriginal communities as helpless victims of historic trauma. But some individuals and families and some Aboriginal communities need to be allowed to heal. We need to stop punishing people. We need to provide Aboriginals with health care that they are owed under Treaty 6. And I'd like to start by showing just some brief statistics. I did a paper back in the fall for legal aid. I'm not going to show too much because I know that Professor Dickson and Judge Barnett are going to be talking about statistics, and I don't want to steal their thunder. but as a spoiler alert, the statistics are awful. But this, I did some work on primary sources, which was the CanLII website, and going from 1996 when the legislation was changed, and just to see, you might recall the legislation was changed to allow more consideration to be taken for the particular circumstances of Aboriginal peoples. And the whole notion was it was to remedy the over-incarceration of Aboriginals in the justice system. But as you can see, this line here is for known Aboriginals, and it continues to rise. It hasn't stopped even till the summer of last year. This line here is for those people where there's no indication that there is Aboriginals. That's not that these were non-Aboriginals, but like a lot of the cases, there's really no indication whether the person is Aboriginal or not. So this, if we had a line for non-Aboriginal, I imagine it would be flat or going down. So I think that there's generally a bias with regards to Aboriginals here in Saskatchewan. So why are Aboriginals disproportionately incarcerated? And as a lawyer, I'm in the business of telling stories, and so I believe in the power of narrative. And I believe that we're strongly influenced by our shared narratives, our shared imagined realities. And here in Saskatoon, we have a sculpture near the riverbank. It's called The Founders. You might have seen it. It's down by the old traffic bridge. It's a sculpture in bronze of Chief Whitecap and John Lake, the temperance colonists. And the backstory to that sculpture goes that Chief Whitecap led John Lake to a spot near the river, which is now Saskatoon. And Chief Whitecap suggested that this would be a good place for the temperance colony to settle. In other words, according to the story, Chief Whitecap gave Saskatoon to the temperance colonists. Now this is a nice story, and everybody likes to retell it. And we rather not talk about the misrepresentation of the Indian Act during the treaty negotiations. We prefer to ignore the intentional starvation of treaty Indians, the ethnic cleansing of the plains to make way for the settlers, apartheid under the Indian Act, and killing the Indian and the child with residential schools. Now, as Judith Herman said in her book, Trauma and Recovery, some acts are unspeakable. And we don't want to talk about nuns holding down a child while a priest rapes that child. And we don't want to talk about the 60% death rate in the early days of the residential schools. And we say, that must be wrong, it's unbelievable. Well, it's unspeakable. These are stories that we don't like to tell. And Judith Herman suggests that it's easier to believe the perpetrator's narrative than the victim's. And the perpetrator only asks that we do nothing. But the victim asks that we recognize their suffering and to action. So as a community, we in Saskatoon, we accept the John Lake story. It's just a nicer story to tell. It's easier to live with. Now, that John Lake story it goes on even deeper than that. We tell ourselves that the settlers that came here to this was a barren and unused land, and with the courage and perseverance and sweat of their brow, the settlers created this beautiful city. However, as the story goes, most Aboriginals have not flourished like the settlers have, and so the suppressed narrative from the shared interpretation of our heritage is that Aboriginals are culturally and genetically deficient because children of Aboriginals are disproportionately taken from their parents and made wards of the Crown. Aboriginals are disproportionately incarcerated. Aboriginals are disproportionately poor in a social and economic sense, and Aboriginals are disproportionately mentally and physically unhealthy compared to non-Aboriginals. So the story goes, there must be something culturally and genetically wrong with Aboriginals, otherwise they would have flourished like the settlers. The historic trauma narrative runs counter to the John Lake narrative, which is shared by the larger community. It's difficult to change a shared narrative that asks little of the listener. And a historic trauma narrative, it asks a great deal of the listener. But the Supreme Court of Canada requires us to listen to the stories of individual offenders and determine their culpability in relation to the notion of proportionality. And that story is best told in a properly researched Gladue report. One of my clients has given me permission to share parts of her Gladue report with you so that you can hear her story. My client was raised by residential school survivors, and many of the survivors of residential schools state that they felt that they did not fit in anywhere. They felt that they could not fit into their home communities and they could not fit into the incomers communities. Some have told the Truth and Reconciliation Commission that they no longer fit in with their families. Some resent their parents. Some cannot stop reliving the moments of victimization even after years of being removed from the trauma. The residential school survivors often experience emotional pain and constant anxiety. And most survivors have encountered, or that we've encountered in our office, we do some residential school claims as well as criminal investigation. They're surprised to find out that there's treatment that can help them. Now, some of the Canley decisions that I read in preparation for my paper had statements from judges to the effect that older survivors of residential schools should have put their residential school experiences behind them. And generally, people think that residential school survivors should just get over it, should suck it up. But most survivors of severe childhood trauma cannot just get over it without some form of therapy. They end up reliving the trauma over and over if they're not treated, and that can go on for the rest of their lives. And they suffer from extreme anxiety, sometimes a deadened numbness and depression. And their anxiety has been described as the feeling that you get when you fall, but before you hit the ground, except that that feeling doesn't go away. Some describe a caustic emotional numbness similar to that's experienced by over-deployed war veterans. And anxiety haunts the survivors when they sleep, if they can sleep, and when they dream. They go to bed with anxiety, they wake up with anxiety. Anxiety erodes their coping mechanisms and crushes their resilience. And anger can be a relief from constant anxiety. Alcohol and drugs are used too often by survivors of that type of childhood anxiety as a relief from their pain. And suicide, too, is often used as a relief. Survivors can lash out in stressful or threatening circumstances, and too many survivors do not know how to parent or how to cope, and they can do harm to children and others around them, especially if they've been self-medicating with alcohol. So let me tie the legacy of residential schools with my client's personal circumstances. And, I'm sorry? 4 minutes. Okay. Saskatchewan legal aid assisted me to arrange a Gladue report for 2 of my clients. And my client's Gladue reporter was an Aboriginal woman with a law degree. Now, the author of the Gladue report determined that my client was raised by residential school survivors, and my client's history was common to most of my Aboriginal clients who have been touched by the legacy of residential schools. There is violence in her home and in her community, neglect, poverty, racism, sexual abuse, repeated sexual abuse, physical abuse, and many of my clients have attempted suicide, and this particular client did as well. And most of my traumatized clients have not been provided with any effective modifiers to their trauma. For example, most of my Aboriginal clients have not had the comfort and protection of a loving, caregiving, safe home. and most have had mobility and insecurity forced upon them. Childhood trauma has hindered their development, and they're blamed for failing to develop in an appropriate way. Again, this intergenerational effect of colonization in residential schools. And my client, like nearly all of my Aboriginal clients, was convicted of criminal offenses as a youth. And she, like all the others, was punished by her offense. Then she reoffended, and then she was punished again, even more, and reoffended again, and the process kept on going with the punishments increasing, becoming even harder and harder. There's no evidence that punishing a traumatized child or any person does any good whatsoever, and there is evidence that punishing an abused person causes harm. Placing a person in jail causes them to become antisocial. Now, a lucky few of my clients are provided with psychological treatment, and the one that I've seen work the best is some form of cognitive behavior therapy. And my client was provided with dialectical behavior therapy, and that was when she was in the Edmonton Women's Prison. And that's a really difficult therapy to deal with, but she went through the courses, and she improved a great deal. Unfortunately, that type of therapy is a therapy. It's not a cure. So when she was let out, her therapy was not continued. And although she did well for quite a while, a major life event came up like it often does, and she went into a downward spiral and reoffended. And now, as a result of being reoffended, she was placed into remand, and in remand, she started exhibiting really bizarre symptoms, so that almost like she was in a disassociated state. And but instead of providing her with proper treatment, they charged her internally and put her into security, and for somebody who has that type of trauma as a background, being in isolation is really the worst thing that could happen. So she spent that time in isolation and up to her trial, but unfortunately, no one told her lawyer about the symptoms that she was facing. She was able to mask her symptoms when dealing with the lawyer. So when the sentencing was done, they weren't aware of her psychotic behavior. She was found guilty, and she was sent to the RPC. Internally, there had been messages between the remand center and the RCP to take her on. So it was decided internally that she should go to the regional psychiatric center, and she was admitted as a secure inmate. So that means that she was in lockdown 23 hours a day. And on the second day, she was let out for the exercise yard, and the women's exercise yard at the RCP, or the Regional Psychiatric Center, is really quite a small area. But she was handcuffed with her hands behind her back, kneeling on the ground and eating dirt off the ground, and one of her hands slipped out of the handcuffs, and the guard went to put her back into restraints, and she swung at the guard, hit the guard with her handcuffed hand, and was charged with assault with a weapon, which is a predicate offense to being a dangerous offender. And it was after that she received more and more isolation. After a few months, she started self-harming, and as a cure for the self-harm, they would put her on a panel board, which is a large plywood sheet that you're tied down to with your arms and legs, sometimes your head. And so they would leave her there, sometimes up to 48 hours. Like, they would come in on the weekend, they'd find her there with her in her own waist. Her depends would have been unchanged for 48 hours. She had been, at some points in near constant restraint. She was in restraint so much that she had to have physical therapy. And she would be placed in isolation for so long that she started to hear voices. I'm sorry, one more minute. I guess the point I want to make is that through her life, she went through an ever-escalating series of punishments, more and more punishment to try and get some sort of, to get her into line. And that seems to be the attitude of not only the system, but our whole culture is to punish, and it really doesn't do any good at all. We had a thorough Gladue report, and as a result of that, she was found not to be a dangerous offender. She's gone off to treatment. It's been a rocky road, but her present psychiatrist is optimistic, and I'm really optimistic too. I really believe in the ability of people to heal, of the elasticity of the brain, and when people are treated with kindness and concern, and are in a safe place where they're respected, there's an enormous amount that can be done. So basically, just to keep Craig from nagging at me, that's it. Thank you.
I don't know how to get yours out and get mine started, so.
It's too bad they left us all alone. Oh, here we go.
Okay, that's not the right,
Yeah,
it's okay. No, that's not what you wanted to do. Okay, let's try this. There we go. Okay. All right, I'm going to try and get through, I think, forgive me, 23 slides in about 10 minutes. So if I start talking really fast, blame it on the half dozen espressos I had so that I could stand up and do this. Okay, what I'm going to do is I'm going to talk a little bit about the experience in Ontario with Gladue. As you will see, because I will talk necessarily about more than Ontario over the course of this presentation, the respect and vindication of Gladue rights in Ontario and across Canada is exceedingly uneven and often highly problematic. The breadth and depth of difference for the respect and vindication of the right across Canada is matched only by the extremely uneven terrain of the reports themselves. To provide a bit of context for the discussion, I just want to talk a little bit about the problem that Gladue is supposed to solve, okay? So we see that Indigenous people constitute about 4.3% in 2011, now probably about, well, more than that now, the population of Canada, and almost 15% of the population of Saskatchewan. I was asked to include some Saskatchewan-specific content here. So, if we look at the population projections for Saskatchewan in particular, by 2045 it's estimated that over a third of Saskatchewan's population will be Indigenous. What we see when we look at the Indigenous population across Canada, and I admit right now the statistics impoverish the reality. Roughly 48% of the Indigenous population is under 25 years of age. Approximately 70% live off reserve, mostly in urban centers, but most Indigenous people, even when you live in the city, you go back and forth, okay? So it's not that you're abandoning home, abandoning your reserve and your community for the city, it's that the city offers a lot more opportunities, okay? So what you tend to do is move back and forth between home and the city. When you're at home, roughly 44% of Indigenous dwelling places are in need of major repairs. Although Indigenous people occupy positions at every level of the socioeconomic ladder, about 52% of Aboriginal children live in poverty, okay? We know that Indigenous people are 3 times more likely than non-Indigenous people to be a victim of a violent crime. As many of you will know, working with Indigenous women, rates of partner violence and family violence in Indigenous communities are often very high. Rates of partner violence in some communities range between 24% and 90% of the population being touched by that violence. And that's in comparison to about 7% of non-Indigenous women. Conditions in those communities, as we'll see, for children in particular, are quite problematic. Although Aboriginal people constitute a relatively small percent of the population of Canada, according to the Office of the Correctional Investigator, they constitute almost 22% of federal prison inmates, about 13.6% of offenders supervised in the community. And as you can see, since 2001, the rates of incarceration of Indigenous people at the federal level have increased significantly. The greatest increases have been seen for Indigenous women. It was not long ago that the Office of the Correctional Investigator horrified all of us by telling us that since 2003, a period of time covered by Gladue rights, the number of federally sentenced Aboriginal women has increased by 80.7%. Okay? So today, 1 in every 3 federally sentenced women is Aboriginal. Now, getting to the local content, we see that in Saskatchewan, the Indigenous population is also ridiculously overrepresented in Saskatchewan jails. 81% of those admitted to provincial custody are Indigenous. 76% of the youth admitted to custody in Saskatchewan are Indigenous. We see, too, that in as little as 2 years ago, almost 64% of the population of the Saskatchewan Penitentiary was Indigenous, and the population of the Regional Psychiatric Centre in Saskatoon contained almost 56% Indigenous people. Okay? We also know, and this is not surprising to anybody who studies what goes on with Indigenous people caught up in the criminal justice system, the Prairie region, which accounts for some of the worst conditions experienced by Indigenous people in this country, also in the jails reflects the highest amount of double bunking, lockdowns, self-harm incidents, inmate homicides, and assaults. Okay? What we see when we go into institutions, when we look Indigenous people in the eye behind the bars, is we see a group of people who are suffering from remarkable rates of trauma and loss and despair. And many of them are doing this, are experiencing this as a direct result of historic trauma. Now, one of the interesting things that has happened with historic trauma is that when you talk to most sort of average Canadians about historic trauma, they only talk about Indian residential schools. Now, don't misunderstand me for 1 minute. Indian residential schools were the architect of a massive amount of historic trauma and historic trauma responses for Indigenous people within this country. But historic trauma encompasses a great deal more than Indian residential schools. Historic trauma includes the traumatic impacts of early contact, which includes culture shock, exposure to disease and foreign religions, disrupted economic, political, and family systems. It involves the wholesale efforts early on by newcomers to rework Indigenous economies, thereby completely altering subsistence patterns, which were significant in shaping cultural and social and familiar relations. It wasn't until a whole lot later that the state got down to real business with policies of civilization and assimilation expedited through Indian residential schools, and they accompanied that with loss of land through treaties and surrenders, some of which were legitimate treaties and surrenders, many of which were not. Okay? So historic trauma involves much more than Indian residential schools. It encompasses a multiple generational experience of loss, state-induced marginalization, and despair. What happens to many people who experience historic trauma is they experience historic trauma responses. All right? Historic trauma responses include things like high rates of depression and self-destructive behavior, suicidal thoughts and gestures, anxiety, low self-esteem, anger, difficulty expressing and recognizing emotions. This is one of the factors that has the most compelling impact on Indigenous children who are parented by residential school survivors. And you see this through the generations. Okay? I've sat down with people who were raised by people who were raised by people who were residential school survivors, and you see how the experience of the historic trauma responses in their grandparents, and in some cases their great-grandparents, filters down through the generations in the form of essentially intergenerational effects, right? When you are raised in a household by parents who struggle with these types of trauma and trauma responses, you are very likely to be raised in an environment where you experience early exposure to violence, usually between the loved ones in your household, early exposure to substance abuse. You will experience poverty. You will experience high residential insecurity and mobility. You'll move around a lot, and most of the houses that you live in will be very substandard. You will experience, in many cases, dissolution of family, foster care, and school leaving. And it is no surprise that each one of those experiences of children raised by those who were direct recipients of historic trauma responses have been shown in the criminological literature to be at a much higher risk of early conflict with the law and who present with reduced life chances and human capital. So, all of this stuff fits in with what we see when we go into institutions. And if we don't fix this, if we don't work meaningfully with communities and families to fix this, if the current rates of incarceration persist and the population projections prove true, by 2035, when Indigenous people in Saskatchewan are a third of the population, the number of Indigenous people in prisons in Saskatchewan may well have doubled. So, what's the magic bullet for all of this? Well, apparently, the magic bullet for all of this is Gladue rights. I'm not going to talk a lot about the right itself. Most of you are probably aware of what it is. It's rooted in changes to the Criminal Code in 1996, which directed courts that are imposing a sentence on an Indigenous person should look into all available sanctions other than imprisonment that are reasonable under the circumstances. And they were to look at these specifically in regard to Indigenous people. This essentially developed into a two-pronged approach. One is looking at the sentencing alternatives. One is considering other types of sentencing procedures that may be appropriate. All right, now, we also, as early as 2013, have a Supreme Court decision in the Ipoli case which pointed out that, echoing the original Gladue decision, that Gladue rights are meant to be remedial. They were meant to remedy the problem of overrepresentation. I think that term remedial embraces much more than just overrepresentation, and that a good Gladue report, well done by a person with experience living in a community, living within culture, and who understands what it means to experience trauma and the effects of trauma, can remedy and begin to remedy some of the traumas and challenges that the individual for whom they are writing the report experiences. So Gladue itself can go towards remedying overrepresentation if Gladue itself is approached as a healing process, right? Now, all Indigenous offenders have Gladue rights. You don't have to have a Gladue report or have attention to Gladue if you choose not to. But if you identify as Indigenous and you ask for those rights to be respected, then they must be respected. So, what has happened since Gladue? Well, the federal Aboriginal inmate population has increased by 56.2%. In the past 10 years alone, there has been a 43.5% increase in federal Aboriginal inmate population compared to a 9.6% increase in Aboriginal inmates. And as I said earlier, the percentage of Indigenous women incarcerated in federal prisons has risen by 85.7%. So, magic bullet? Maybe, but whoever was shooting it got a real bad aim. So, why has Gladue at this point failed? Well, I'm going out on a limb here, but I'd say there are 3 broad reasons why Gladue has not been the magic bullet that we all thought it would be. First, ignorance. There is a lack of understanding of the right by pretty much everybody involved. Resources, which are, for the most part, unwieldy, unworkable, and inadequate. And risk-need realities of the Indigenous population. It's going to take a lot more than a legal remedy to address the high offending rates which are directly associated with historic trauma and historic trauma responses. We have to do better, which means we have to move outside the courts. So let's get direct and to the point. In my experience working in Gladue, it is my view, and I'm speaking, these are my lessons from Ontario for you folks, there is a critical mass of court personnel who don't understand Gladue rights, nor do they understand the necessity, meaning, or intended contribution of a Gladue report. Okay, so what have we found? Well, when it comes to judges, and in 2013, the Federal Department of Justice conducted a survey, a national survey on Gladue. And they found that training for judges in Gladue principles, as well as in Aboriginal culture and history, was available in only about 5 to 6 jurisdictions. And that was largely in the form of workshops. And there were comments in that research by the judges that said the quality of this training is not very good. Okay, you'll be pleased to know Saskatchewan has that training. No such training is provided to judges in Nunavut and the Yukon because, quote, judges are faced with cases involving Aboriginal persons every day, so no formal training is necessary. Okay. Problem is, having general knowledge of Indian residential schools and land surrenders and so on, 3 minutes, okay, doesn't equate with having direct individualized knowledge of the person who is standing before you and of whom you are standing in judgment, okay? I've done extensive Gladue work in northern Quebec. The only time they seem to pay attention to Gladue rights is when somebody like me is sitting there drumming my fingers. And then I've seen judges actually stumble over even knowing the number of the criminal code section, okay? Moving on, Crown prosecutors. In my experience, Crown prosecutors really don't like these reports. I don't know what makes them so hostile. I think the reports are pretty good. But what seems to be the case with prosecutors is they don't seem to make the connection that this is a report that speaks to sentence. It speaks to sentence. Consistently, I deal with prosecutors who attack them like they're evidence and the trial is still ongoing. Imagine this. You are an Indigenous person. You are facing a probable loss of liberty. You have sat down with someone and told them your life story. You may have opened up wounds and exposed yourself and made yourself vulnerable in a way you have never done. And if you're really lucky, you have a good Gladue writer who understands the healing process of Gladue. So your process of getting a report was a safe one. And then you find yourself sitting in court beside your defense lawyer, and you see the Crown going through the report, attacking your statements because they're hearsay. Yeah, they're hearsay, but it's speaking to sentence. They can be hearsay. We're telling a story here. You need to listen to the story, not attack it like it's a piece of evidence, okay? Defense bar. Sorry, guys. I know this is supposed to be from the perspective of defense counsel. But what we have also seen and what I've seen is that there is uneven knowledge of the right by a lot of defense counsel. They're not sure when it kicks in, and they're not sure who qualifies. If I had a nickel, as I was saying to you guys at lunch, if I had a nickel for every time I have watched an Indigenous defendant sit there while a non-Indigenous judge, Crown, and lawyer have a discussion between them about, is he really Aboriginal? I'm not sure he qualifies. And the number of times I've had Indigenous Gladue clients say that was the worst thing that has ever happened to me. I sat there and they erased me. Okay? Not the healing experience of Gladue. Defendants often don't know their rights either. Okay? We're not doing a very good job of making sure that Indigenous people are aware of what their rights are. The remedy for that? We need training. We need training everywhere. We need greater community education, empowerment of Indigenous communities so that they know their rights and know that they can actually stand up and demand vindication of those rights. Much greater training for all court personnel, and I would argue better coercive oversight in the handling of Gladue rights. It's not enough to say, oh, if you don't get a Gladue report or you don't get a good Gladue report, you can appeal. If you're there being defended by a legal aid lawyer, do you know what you're up against trying to get an appeal, especially on that basis? Good luck. Resources are inadequate. The budgets are simply insufficient to allow all the need to be met. In Ontario, the primary Gladue provider is Aboriginal Legal Services of Toronto. They're doing the best they can with very little. Last year alone, according to Jonathan Rudin, they produced 162 reports. Okay? Last year, in 4 months, in the fall, I produced 60. And you know what? Between us, we didn't begin to touch the need. Okay? Not all of Ontario is covered by ALST. So sometimes what they do, 1 minute, right? Sometimes what they do is they'll try to contract with friendship centers to provide these reports. A lot of friendship centers don't necessarily want to do this. And most of the people who are being asked to do it at friendship centers have not received any kind of training to do so. I have been in the position of having a report ordered to ALST. ALST sends it back to the court because it's not part of their catchment area. The court then sends it to the Friendship Center, and the Friendship Center then calls myself and some of my colleagues, can you write this report? I don't know how to do it. I don't want to do it. I don't know why they're making me do it. And then you go back to the court and explain to the court that you're going to do it. So there are huge problems with the manner in which we are resourcing the writing of Gladue reports. There are huge difficulties in terms of the training which is provided to Gladue writers. Gladue writers, it's not sufficient to say that if you're Indigenous and you went to law school, you can write a report. Okay? There is a great deal of this which is about experience. There is a great deal of this that is about knowing what it's like to live on reserve, knowing what it's like to spend your day with people who are struggling with trauma. There is a great deal of this that goes to knowing how to talk to people about some of the most painful experiences in their lives and not leave them in tatters. Okay? A Gladue writer who doesn't know how to conduct a healing type of interview is a dangerous Gladue writer. So, very quickly, we need to totally rethink the way we structure our funding of Gladue writing and Gladue reports. We need to commit to serious training, and I think we need to commit to taking that task out of the hands of legal aid. We can talk about that more if I have more time at the end. Finally, risk-need realities. Courts deal with legal problems. That's what they deal with. Okay? We have a demand for Gladue because we have a very complicated set of social and political and economic problems. Courts are not going to be able to address those. We need to engage in some serious attention to healing in and with communities. We need to address historic trauma and understand that it is so much more than Indian residential schools. We need to understand that the impacts of historic trauma feed directly into the overrepresentation of Indigenous people in jails, primarily and most obviously seen in the high rates of family and lateral violence that exist in some communities. This stuff is at epidemic levels in many, many communities. We need to address poverty. We need to address blocked opportunity. We need to address marginalization. So, unless we're prepared to seriously commit to Gladue, the future is not going to get a whole lot better in terms of the recognition and vindication of this right. We need to address the funding deficits. We need to address the knowledge and training deficits. We need to respect the right of Indigenous people to take control of the Gladue right and to force the decolonization of Gladue, because this is what is happening in many areas of this country. Gladue is being colonized. Okay? When you can have a non-Indigenous judge in Nunavut say, I don't need a Gladue report because all I got to do is look out the window. Sorry, that's not acceptable. Okay? And we also need to commit to legal changes that are accompanied by broader social and political change and commitment. If you build up communities, you don't have to build jails. Thank you.
Well, I'm going to start by telling you that Jane Dickson has told you some of the things much better than I would have told you, and I agree with everything that she said. The next thing I'll tell you is that I did, before coming here today, write out some speaking notes. And I'm not going to just read those speaking notes, but I actually think that there's some information there that some of you will find valuable, and you can get it by getting in touch with Lori Sorowski, who's the faculty executive assistant here at the law school, or by getting in touch with Kim Pate. Either one of them, if you email them, they have it and they will send it to you. And there is, I think, some information there that some of you will find valuable. I'm also going to start by kind of asking you, are there some law school students here? Some? Any practicing lawyers here? And last question, are there any judges in the audience? I'm going to tell you that when I came to Saskatchewan, to Saskatoon, in January last year, the first of 2 times to work with Aboriginal court workers and with legal aid lawyers, along with Pamela Shields, the 2 of us were doing some Gladue education. And we got started, and very early on that first morning, one of the women who was there, and I don't know whether she was a court worker or a lawyer, she asked a question, and I didn't understand fully the importance of the question right when she asked it, but I sure as heck do now. She said, Pamela, Judge Barnett, this is all really good, but who is going to teach the judges? I'm not going to say more than that. That question was really perceptive. And I've been considerably involved with the Truth and Reconciliation Commission. Mr. Justice Sinclair said, and boy was he right, he said it took a long time to create these problems, and it's going to take a long time to fix them. And I think it was Jim who said, and I'm sure many of you have heard it, I've certainly heard it from all kinds of people who say, Judge Barnett, why can't those Indians just get over it? And some of the people who have said that, they don't say it publicly, they don't repeat it in the courtroom, but they sure do in chambers, are judges. It's not fair. And it's not fair either to think that Aboriginal communities or Aboriginal people can fix it. It's Canadian society, all of us. And we've got a much bigger role than many of us appreciate. I have spent some time doing a workup of what's going on in Saskatchewan. When I was here in September last year as a panel member of Legal Aid Lawyers Conference. I was, perhaps some people thought, quite outspoken. A reporter with the Star Phoenix, Hannah Spray, wrote what I thought was I thought it was a good story because she certainly represented absolutely accurately what I had said. Some people thought it was far too outspoken for a retired judge from a different province. And Mr. Justice Van Cise, a former, like myself, a former judge, but a former justice of the Saskatchewan Court of Appeal, wrote a letter and said that I didn't know what I was talking about. Well, with all due respect, Mr. Van Cise, I did know what I was talking about. I wasn't such a damn fool that I would come to Saskatchewan and start spouting off if I didn't know that I was on solid ground. But his letter sparked an interest in me, along with the Andy Peekakoot dangerous offender case from Saskatchewan, that I had some role in trying to take that case to the Supreme Court of Canada, which did not grant leave. But one of the things that I did, and I don't think I would have done it except for Mr. Van Cise's letter, was I sat down and went through every single Saskatchewan Court of Appeal criminal sentencing decision from the time of the Gladue decision up until the time of Andy Peekakoot's dangerous offender decision in September of 2014, 15 years. And with some difficulty, as I explain in the material, if you're interested, you can get from Ms. Pate or Ms. Sorowski, but with some difficulty, I identified 147 cases in which the Saskatchewan Court of Appeal had dealt with the sentencing of an Aboriginal person. And I looked and read each of those decisions, and how many of them even considered the Gladue principles. Well, the number is in the material you can get, but it's not very many. For coming here today, I isolated how many Aboriginal women had their cases considered in the Saskatchewan Court of Appeal over that time period. 14. And I identify each of those cases and where you can find them in the material that I wrote up, thinking that I might run a bit short of time. And I have read each of those cases really carefully, and I've gone back and looked for and found most of the provincial court decisions, if it was a provincial court decision at trial, or the Queen's Bench decision if it was a Queen's Bench case at trial. And I'm going to tell you, and I'm on very solid ground, that the Saskatchewan Court of Appeal not only has not very often mentioned Gladue principles, period. The Saskatchewan courts are not leading the rest of the courts in this country when it comes to Gladue. But in some of the cases, I think is quite clear. The court is hiding or attempting to hide the fact that an Aboriginal person is being sentenced. And you have to work very hard in some of the cases to be absolutely certain. Some of them, the first case of this kind that came to my attention was a case reported only as BW or BJFW. And I looked harder, and I found, his surname is White Deer. Well, I'm pretty sure that that's an Aboriginal person. But I was pretty sure. But I looked farther and found out that he's a typically tragic Aboriginal offender, disconnected from his community, badly urbanized. I talked to his lawyer to get it for sure, and he said, you know, Billy White Deer never had a chance. Whew. Then, because I was working on the Andy Peekakut case, I went through and looked at all of the Saskatchewan dangerous offender cases over that 15-year period. Some of the cases were heard and decided in the provincial court, never appealed. Some were in the Queen's Bench court, never appealed. And some went to the Court of Appeal. But I got every case that was started and ended in that 15-year period. The government could produce these statistics for you in about 5 minutes, but they will not. I tried, and I was told by somebody who was very knowledgeable and had inside information that it's absolutely impossible to pry these statistics out of the government. But in Saskatchewan, what percentage of the persons, and they're all men, who got declared dangerous offenders are Aboriginal? 77%. That's shocking. 14.9% of the Saskatchewan population. The statistics for dangerous offenders in Canada generally are bad enough. They're getting, I think, close to 30%. But in Saskatchewan, it's 80%, darn near. And that's not right. What Jane Dickson said about Gladue principals going far beyond residential schools, she's absolutely correct. You will not find any decision in Saskatchewan in the Court of Appeal where the court has mentioned Gladue principles, but it starts at the residential schools. There's not a single mention of anything back of the residential schools. But there are some books from Saskatchewan that are really good. And every judge in this province, and not only in Saskatchewan, but they are Saskatchewan-focused books, but every judge in this province, I believe, should be reading 3 books for sure. The first one is A Geography of Blood. The titles are in the material you can get if you're interested. A Geography of Blood, written 3 years ago by Candace Savage, a wonderful author. And you know from the title of her book, A Geography of Blood, that it's not a gentle story, but she starts it out beautifully written as a very gentle story. And you're about 2/3 of the way into the book when she starts hitting you with why there are no Aboriginal people in the most beautiful part of Saskatchewan. At least some people think it. Many people think it's the most beautiful part of this province, the Cypress Hills. There are no Aboriginal people there. How come? Well, there's a real colonial story that people want to forget. The other book, Clearing the Plains, written by James Zastruck at the University in Regina. And he, oh, it's wonderful irony. He won last year the National Award for the best nonfiction book of 2014, the John A. Macdonald Prize. And, you know, you can summarize his book by saying he tells you the story of political events back at the time of Confederation, when John A. Macdonald, ramming through the CPR across Manitoba and Saskatchewan in particular, so that the province, the territory could be opened up for white farmers, and that meant that the Indians had to be starved off and forced north. That book tells you the story that Jane Dickson was talking about. And in the other book, and I'd like to think that most of you here today have read this little book. It's a wonderful book. The Education of Augie Morasti. Just published last year. It's a really wonderful little Saskatchewan book. He's a homeless man in PA. And with the help of in great interest of a prof at the University of Regina, he tells the story of his residential school experience in a moving way, and I've read, I think, most of the survivors' books. His stands alone. And with that, I think I'm going to sit down. One other thing I wanted to say. This morning, it was the senator who mentioned the case of Cindy Gladue, and that just brought a flood of memories back to me. When I started as a young lawyer, there was a case decided out of Williams Lake where I was a judge for 25 years, starting a few years after that. 3 white guys picked up a Native girl in Williams Lake, 19 years old. They got her drunk, and you know what they did with her. They took her to a gravel pit, and you know what happened in the gravel pit. And after that, they threw her naked out of the car or truck into the gravel pit. She died of exposure. They got charged with manslaughter. There was a jury trial. One of them was acquitted. The other 2 were found guilty of common assault. Fined $200. There was an appeal, as is going to happen in Cindy Gladue's case. The Court of Appeal imposed the most sentence it could, 1 year in jail, common assault. Nothing much has changed, some people would say. You can read the decision in that case. It's in the Canadian criminal cases. It's a 1968 decision. I went and found it in the library at noon today, and that's why I was a little bit late.
Thanks, Judge Barnett.
Thank you.
Well, we've overstayed our time. I hope we haven't overstayed our welcome. And it's hard to wrangle when people are as passionate and as informative as Jim and Jane and Cunliffe have been. So I'll do my mea culpas to the conveners for having let this run long. I think Jim, Jane, and Cunliffe will be here for the rest of the day and tomorrow. So if you have some questions, don't hesitate to talk to them. They're all affable, and they're all keen to talk. So with that, and my apologies again for spending the extra time, we'll close. Thank you.